The agenda is the approval of minutes of our April 2nd meeting. Is there a motion or are there additions or corrections? Is there a second?
I second.
Okay, all in favor?
Aye.
Aye. Is a continuation of the case involving 122 Tingle Road requesting a variance from the required setbacks from Upshur Lane to the accessory building, which is located at 122 Tingle Road. And we had tabled this meeting the last time because we did not have a location survey where it indicated the actual distance of the accessory building from Upshur Lane. It is a corner lot and therefore had a required extended side yard because it was also in some circumstances considered a front yard. And Mr. Bunning, you graciously, I will say, offered to do a location survey, and I believe in our packet we have a copy of that location survey that you did. So you have analyzed the distance between the accessory building and Upshur Lane, correct?
Yes, I have.
Okay, and
For the record, the distance from Upshur Lane to the closest corner of the accessory building was 11.1 feet, and it was proposed in the application for the building permit by 10. So that exceeded what was required there. The application for the permit was proposing an 8-foot dimension off the existing two-story dwelling. I find that to be 7.7 feet, which is, and again, these measurements are from siding to siding, but probably would be very close to an 8-foot dimension, measured foundation to foundation. However, it is only required in the zoning code that buildings, accessory buildings, be a minimum of 6 feet off another structure anyway, so 7.7 would meet that requirement.
okay, so the only reason that we are considering the issue is because as a corner lot, there was that additional requirement that's supposed to be adjacent to the principal dwelling, correct?
Yes.
All right. And I will state, I will find out who's here in a minute, but I will state that the survey by Mr. Bunning of the accessory building as-built survey shows the rear of the property on what is designated as Lot 16 to be a stormwater management pond, correct?
Lot 18.
I'm sorry. What did I say?
66. 18.
18. And on Lot 18, of course, with a stormwater management pond, it is correct that that makes that lot unbuildable,
True.
right?
Yes.
Okay. All right. So, Ms. Boland, you're here. You have been sworn in, of course, and you folks are the applicants. Is that correct? All right. Before we go further, I will invite you all. Were you sworn in at the last hearing? I don't remember.
No, I don't believe so.
All right. If you'll stand and raise your right hand, please. You do solemnly declare and affirm under the penalties of perjury that the testimony you give this board is the truth.
I do.
Okay, state your name. You may be seated. State your name and address. Then.
Jeff Anderson, 122 Tingle Road, Berlin, Maryland.
Okay. All right. Now you can sit down. That's fine. And ma'am, are you going to testify or? Oh, okay. That's fine. All right. Did you and Mary? Did you have anything? Well, let me say for the record, I took a photograph of the accessory building after we tabled the hearing the last time, and I had given that to Ms. Hardesty. So we'll have that in evidence, and then each of the members of the board also have a copy. So we'll consider that in evidence. And I will ask, for the record, the photograph that is there, is that an accurate photograph of the accessory building?
Yes, it is.
Okay, very good. All right. And Mary, did you have anything that you wanted to add to your testimony that you gave us last time?
I do not.
Okay. And sir, do you have anything that you want the board to hear from you at this time? It's your right to speak.
Not at this time.
I'm sorry?
Not at this time.
Okay, all right. Any comments or questions from board members? I will say that it should be noted that in the code, the definition of an accessory building is set forth in the definitions section of the code. And an accessory building should contain accessory living quarters, meaning an accessory building used solely as temporary dwelling of guests of the occupants of the principal dwelling, such dwelling having no kitchen facilities and not to be rented or otherwise used as a separate dwelling unit. And do you have a kitchen unit in the building?
What constitutes a kitchen unit?
Well, a kitchen unit would be a facility used for cooking.
I would say it'd be a microwave and a coffee maker.
A microwave and a coffee maker,
No ovens, no dishwasher.
okay? And where are they located? We do not have a floor plan of the building. What is on the first floor of the building? If I walked in? How many rooms?
Proposed bathroom, just that little kitchen nook or whatever you want. I don't know what to call it.
Well, kitchen nook is a problem. Yes, ma'am. If you can tell him to testify if that's more comfortable for you.
I'll try to
Well, I apologize, but if you're going to testify, I've got to swear you in. You do solemnly declare and affirm under the penalties of perjury that the testimony you give is the truth.
Yes, I do.
Okay.
There is no kitchen. We plan on having like a little bar eventually with a microwave and a coffee maker. Eventually, because it's going to be my studio, my arts and crafts studio. So we're not going to have a kitchen. It's not finished. It's not finished. But I'd like to have a little area to have a microwave.
Okay.
Refreshments.
Well, I will just tell you that the wording used is kitchen facilities. And I guess it'll be up to the board as to whether a microwave, I don't think a coffee maker is a kitchen facility. It'll be up to the board to determine whether a microwave is. But I'll be honest with you. When I saw the fact that you have a two-story dwelling, well, two-story building, let's put it that way, in the rear of, and it's very nice looking. It complements the neighborhood. But as an accessory building, it cannot be used as an Airbnb, it cannot be rented, and it can only be temporary quarters for guests or members of the family.
I understand.
And I will say for the record that I'm sure you understand that the town of Berlin has the right to send inspectors on reasonable notice to enter into a property to see that it is being properly used. Now, the board has not voted, so I'm not making any prejudgment, but it has to be utilized as an accessory building with the accessory dwelling living quarters utilized in it. So as long as you all understand that, then the board would vote on that basis but not to extend. The board doesn't have the right to extend the provisions of the code unless we are given the right under the authority of the Board of Zoning Appeals. And an accessory building is intended to be that. So,
I understand.
okay. Anything else you all want to bring to our attention? Is there anyone in the audience who wishes to speak for or against the application? There is no one who has raised their hand. Any comments or questions from board members?
The only comment I would have is I was concerned when I initially saw the building that it was going to be used as a rental unit, as an Airbnb, but he testified it's not the intent. And, it is a nice looking building. I was surprised it had a deck on the back as well as porches on the front, but if it's to be used, as you state, as an accessory building, I don't have any problems with it.
I simply say that we really wanted to add on to our house, but we weren't allowed to this extension of our living space. And, you know, for a family member to stay in my studio, it's a cramped studio.
And I think you have the right to use it for a family member to stay in, is that right?
That is correct. That is correct. They used to be called mother-in-law apartments, but that's not politically correct anymore. But again, with no facilities that would make it in the nature of a principal dwelling. It has to be an accessory dwelling. And the other thing that is interesting about it, and it's to your benefit, with lot 18 to the rear being a stormwater management pond, there's no one behind there that's going to be adversely affected. And you are to be congratulated in the sense that you designed it to facilitate the neighbors. Any other comments or questions?
Well, my question was basically answered to your question concerning the kitchen facility. Are you going to use this also as a studio?
In my upcoming retirement years, I wanted to have an arts and crafts studio. It's not a business. I have friends and family, and I want to have things to do in my retirement. That's why I want to have like a coffee maker, a little fridge or something, you know, refreshments. Guests stay there, my family, my mom, you know. Just extension of our home.
Okay. Anything else? If there's no comments or questions, the board will entertain a motion.
I so approve the motion to go ahead with your plans to construct the building as stated as far as the definition. I so approve.
Okay, so the motion is that it would be granted and the accessory building would be occupied solely as a temporary dwelling to guests of the principal occupants and shall have no kitchen facilities, shall not be rented or otherwise used as a separate dwelling unit. That would be part of the motion.
I didn't memorize that sentence.
Well,
but that's
I didn't
what-
either. I wrote it down. So,
I saw.
is
I'd
there
like to add that I don't consider just a microwave enough of an appliance to make it a kitchen. I think a microwave is satisfactory.
Yeah. Yeah, I agree with that.
And I will second
Okay.
the motion.
All right, been moved and seconded. All in favor of the motion to grant the accessory building subject to the conditions stated in the motion, say aye.
Aye.
Okay. All right, and folks, I have stood aside for the next hearing, and so I will excuse myself, and Mr. Bunting, the co-chair, will act as chairman. Okay, thank you. Well, I did because I just got back from walking 4 miles in New Jersey when I was in Maine, and I wouldn't have done it. Thank you. All right. Thank you.
The next agenda, case number BA 5-7-2504, requesting to reduce the applicable parking requirements for the proposed micro-hotel development. Mr. Crocker.
Mr. Chairman,
Thank you.
Mary, would you like your own copy? I have extra.
No, that's fine, because
You're
it'll
okay?
just go in the record.
Mr. Chairman, I'm ready when you are.
You may proceed.
Thank you. So for the record, Mark Spencer Cropper, 6200 Coastal Highway, Suite 200, Ocean City, Maryland. And I'm the attorney for the applicant, who is the developer of the proposed Microtel Hotel. And just also for the record, this matter has been before the Town of Berlin Planning Commission. I've kind of forgotten how many times. I'm going to say about 3 or so on a number of items, but most recently on the elevations of the building and preliminary site plan. But because of the moratorium, we were not able to return to the Planning Commission for final site plan approval until such time the moratorium got lifted. New zoning administrator has been hired. So after this evening's hearing, should the board look favorably upon the request, we'll be having to return to the Planning Commission to get site plan approval. Okay. So to my immediate right is Brett Ewing, and Brett is the planner for the project. And for the benefit of the board members, Mr. Ewing's resume and CV is number 8 in your binder. So Brett, if you will just very briefly describe your educational and professional background for the board.
Before you get, should I swear in?
If you would like to do that now, because all 3 will be testifying,
Yes,
yes.
you all want to stand and just raise your hand. Do you declare under the fountain of perjury the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Just if you will state your names for the record, and, well, you're going to introduce yourself.
Yes.
You want to do it?
So go ahead,
Okay.
give your full name and address for the record.
Yeah, so it's Brett Christopher Ewing, I'm a principal at Lane Engineering. That is at 117 Bay Street in Easton, Maryland. My background is just an education, bachelor's degree from Salisbury University in land use and planning. I have over a decade of experience in the public sector in the planning side, the design side, and environmental side of development regulations. And since then, I've been with Lane Engineering for almost 8 years now.
And you're a planner by trade, is that correct?
Correct.
And you were engaged by Mr. and Mrs. Zambetas to assist them, represent them with regard to the Microtel Hotel?
Correct.
You've been qualified as an expert planner before other administrative bodies throughout the state of Maryland, is that correct?
Yes.
I'm going to be offering the testimony of Mr. Ewing as an expert planner for the purposes of this hearing. Then beside Mr. Ewing is Mr. Ernie Felici. Your full name and address for the record, please.
My name's Ernie Felici Jr., 36619 Tanger Boulevard, Rehoboth Beach, Delaware. I'm with Beacon Hospitality. My background is I graduated from Villanova University 25 years ago. Spent 15 years as a broker of record for Cushman & Wakefield in commercial real estate. Been with Beacon Hospitality for the last 4. I've built 4 microtels as well as a chief operating officer for Beacon Hospitality.
And for the benefit of the board members, also under tab 8 in your binder is leadership team for Beacon, and on the second page of that is Mr. Felici's background that he just summarized for you. To the right of Mr. Felici is Mr. Zambettis. Tom, your full name and address for the record, please.
Thomas Zambettis, 12516 Sycamore View Drive.
And you're the owner/developer of the proposed microtel, is that correct?
Yes.
And you engage the services of myself, Mr. Ewing, and Mr. Felici to assist you with this project, is that correct?
Yes.
And in fact, you attended the various planning commission meetings with myself that I've already informed the board of, is that correct?
Yes.
All right, I'd like to direct everybody's attention to tab 1 in your binder. And these are documents, I believe, that were also provided to you with the staff report. But the request this evening is for a reduction in the code required parking for the microtel hotel. And as you also know, again, from your staff report, section 108-788D4 of your code states that the Board of Appeals may authorize, subject to the provisions of section 108-160 through 108-165, a modification, reduction, or waiver of the foregoing requirements if it should find that in the particular case appealed, the peculiar nature of the residential business, trade, industrial, or other use, or the exceptional shape or size of the property or other exceptional situation or condition would justify such modification, reduction, or waiver. Then I will also direct your attention to the next letter dated March 24, 2025.
I'm sorry.
It's okay. It's your hearing. You're the boss.
That's fine.
It's a catchy tune. I'll do that.
Sorry.
It's quite all right. So the next document in your folder, also under tab 1, is a letter dated March 24, 2025, that I delivered to Ms. Hardesty, the new zoning administrator, indicating I referenced section 108-163A of the code, which reads, the Board of Appeals shall have the power to hear and decide application for conditional uses or for decisions upon other special questions or exceptions on which the board is authorized by this chapter to pass. The board shall have the power to authorize on appeal in specific cases a variance from the terms of the ordinance. All such applications shall be deemed to be for special exceptions authorized by the general code. So this matter before you, seeking a reduction in the required parking for the project, I will be addressing the criteria for special exception unless somebody would indicate to me otherwise. Mr. Zambettis, you not only retain the services of myself, Mr. Ewing, and Mr. Felici, but you had the opportunity to review the application for the reduction in parking that I've described to the board. Is that correct?
Yes.
And you've authorized me to proceed this evening for the purpose of achieving that reduction.
Yes.
Okay. So I'm going to return to Mr. Ewing because he knows more about this than anybody. And I'm going to direct the board's attention to tab 2 in the binder. And what I had Mr. Ewing do, now with the actual application for the reduction in parking, there was a site plan submitted. I thought it might be helpful to have Mr. Ewing overlay that site plan on an aerial photograph of not only the subject property, but also showing the surrounding properties. And there you go, so it's up on the screen. So if you will, Mr. Ewing, generally describe first the microtel structure, meaning how tall, how many stories, how many rooms?
Yeah, so as you can see in that drawing, where the label proposed 4-story hotel, obviously it's 4 stories, 77 rooms. You have your footprint is 8,700 square feet roughly, just based on the drawing there. You see our parking spaces that have been provided on site. The required stormwater management features, which is in the front, between the parking lot, inside the parking lot, and then you have a larger feature to the north behind the building. You can see the bold line, bold black line that kind of outlines the overall parcel. The parcel itself is a touch over 5 acres. As you can see beyond our stormwater feature north of our building, that entire wooded area is considered non-tidal wetlands, and that has been delineated and confirmed by Maryland Department of the Environment.
And the code, the Berlin code requires 83 parking spaces. That site plan shows 69, and therefore we're seeking a reduction of 14 parking spaces. Is that correct?
Yes.
And in addition to the site limitations you just described, again, you've got the stormwater management issues, the non-tidal wetlands, and you also have the State Highway Administration access easement, and then the standard code required setbacks. Is that correct?
That's correct.
So a site that is 5.131 gross acres, I believe, you've indicated that there's only 1.75 acres actually usable as what I'll call a net building envelope. Is that right?
That is correct.
And so it seems like it's a fairly large parcel, but in reality, it's not large at all. And with the building, the parking lot, the parking that's shown on that rendering, do you believe, in your professional opinion, favorably upon the reduction of 14 parking spaces?
Yes, I do.
And the reduction of parking spaces is consistent with codes in other areas, is that correct?
Yes.
So I'm going to direct the board's attention to tab 4 in your binder. And what we've done, and this is really for informational purposes, Mr. Ewing was kind enough to look at the parking requirements in some of our local jurisdictions just for comparative purposes. And the first town that he looked at is Easton, so the first set of parking requirements is from Easton. Beyond that, we also have Ocean City, and then beyond that is the city of Salisbury. And Mr. Ewing, correct me if I'm wrong, but each of the code provisions for Easton, Ocean City, and Salisbury, those codes require parking for a similar use, this hotel, consistent with the number of parking spaces we're providing, which is 69, correct?
That's correct.
So even should the board look favorably upon the reduction in parking, this project, if in those jurisdictions, would be code compliant.
That's correct. Yeah, Easton, it would be, I think it's 60, in the 60 range.
Okay.
Yeah.
I'd like to direct the board's attention now to tab number 5 in the binder. And this is a letter dated March 13th, 2024. And for the record, by the way, the binder, I'm going to have marked as applicant's exhibit number 1 for the purposes of this hearing, for evidentiary purposes. There's a letter dated March 13th, 2024, and Mr. Zambettis, this is a letter from Neve Properties LLC that was provided to you when you entered into the contract to purchase the subject property. Is that correct?
Yes.
And I'm going to read into the record, it's a very short letter. Gentlemen, as you're aware, Neve Properties LLC, Neve, owns the following properties which adjoin the above property and have a shared parking arrangement. 611 Franklin Avenue, 615 Franklin Avenue, 617 Franklin Avenue, and 619 Franklin Avenue, known as Franklin Avenue Properties. Please accept this letter as confirmation of Neve's intention to permit A&M Investment Properties LLC or its successors access to a non-exclusive use of 24 of the shared parking spaces currently located at the Franklin Avenue properties once it acquires fee simple ownership of the property. Please let me know if you require any additional documentation regarding this matter. I'm available to answer any questions. You relied upon that letter in proceeding to closing on this property, correct?
Yes.
And you, in fact, have closed on the property, and therefore this offer by Need Properties is deemed in place and effective today. Is that correct?
That is correct.
Okay. Mr. Felici, Beacon Hospitality plays what role in this project?
Beacon Hospitality is the project manager for Mr. Zambetis for the development of the hotel, as well as the management company once the property opens.
And you're intimately familiar with microtels throughout. As you've indicated, you've been involved in the development of numerous microtel hotels. Is it fair to say that with regard to this specific issue, meaning a demand for parking, the greatest demand for parking for a microtel is in the evening, correct?
Correct.
You're also familiar with the properties, need properties that are identified in that letter dated March 13th, correct?
Yes, sir.
And those are all commercial properties on a neighboring property which have their greatest demand during the day, not in the evening nor on weekends, correct?
Correct.
So to the extent that Need Properties has offered the availability of these 24 parking spaces on the neighboring property, and the timeframes of when any demand could possibly be generated by the microhotel or any demand by the commercial businesses on those properties, there is no conflict. Would you agree with that?
I agree.
And in fact, they complement each other because to the extent both properties are in need of parking, they're completely different time periods.
Correct, they're not competing.
Okay. I'm now going to direct the board's attention to tab 6 in the binder. This is a letter dated April 15, 2024. And Mr. Ewing, you've seen this letter because it's one of the documents in the binder, correct?
Yes.
And this is a letter that was written by Mayor Zach Tyndall on behalf of the town of Berlin to Jennifer Keener, the Director of the Department of Development Review and Permitting in Worcester County. Because the county is in the process of updating its comprehensive land use plan, and one of the issues as part of that undertaking is designating future growth areas in and around the town of Berlin. This letter says, among other things, the town of Berlin does not want any additional or new growth areas to expand the town limits, and the town wants to concentrate on the development of only infill properties, correct?
Yes.
So I'm going to direct the board's attention to that letter, April 15. First question, are the existing growth areas adequate to provide for infill development and any additional growth anticipated by the town? The answer, the town of Berlin believes that the existing municipal boundaries are adequate to provide for current and future development needs, and that no additional growth areas are needed at this time. I've now directed your attention to question 2, are those areas too large or in the wrong place? And one part of the answer is residential growth will be focused on infill development within current municipal boundaries. You go to number 3, are they consistent with the current and any proposed municipal growth element in Berlin? Refers to answers 1 and 2. The town of Berlin would like to focus on infill development within our existing municipal boundaries to protect the look and feel of the small town. The reason I'm bringing this to the attention of the board is this. The town of Berlin has made quite clear to the county that's updating the comprehensive land use plan, they don't want to grow. The town wants to concentrate only on existing lands within the limits of the town of Berlin, of which this property is one. So we have a developer that's proposing to develop this property pursuant to your B3 zoning and trying to take full advantage of that property accommodating this use. To facilitate that, we're requesting from the board a reduction in required parking because we have a limit on the amount of acreage within this site. So I believe it is consistent with the town's position that they want to concentrate on infill development only to support this request by this developer who's trying to maximize the development potential for a property in the town limits. That's why I supplied that letter to you, because I don't know how many people know the town of Berlin has taken this position with regard to its future growth areas or lack thereof. Under tab 7 of the binder, all I've done is gone into the Town of Berlin Comprehensive Land Use Plan and copied pages that are relevant to this particular project because this project is commercial in nature. It's located on US 113. I'm just going to summarize that these pages of the comprehensive plan support the fact that commercial development is supposed to be concentrated along certain portions of Berlin, of which this is one. It's zone B3 under the B3 code in Berlin. Also, all uses allowed in B2 and B1 are also allowed. So this project not only is consistent with your zoning code, I believe it's also consistent with your comprehensive land use plan directing some of your more intense development along 114. Tab 8, you've already seen, which were the resumes or CVs of Mr. Ewing and Mr. Felici. Under tabs 9 and 10, and I only did this for the record, I don't expect board members to sit there and read any of this, but there are a couple cases in Maryland that I believe are relevant to this request. One is on special exceptions, one is on zoning by the plebiscite, but as far as special exceptions, I'm simply going to summarize all special exceptions are presumptively permitted uses, and all special exceptions are deemed to have some type of impact. The question for a Board of Appeals on a special exception isn't whether there's an impact. It's whether the impact at a particular location is somehow more egregious, more detrimental, more impactful on a neighborhood than that use would be elsewhere of similar zoning. So the impact has to be greater for a board to deny a special exception. It's not just that there are impacts, that the impacts at this location have to be different and greater in degree than they would normally be elsewhere of similar zoning. So if the microhotel was being located on another B3 zone property in Berlin and somebody is requesting a reduction in parking, it's not enough that there may be an impact from the reduction. The impact is presumed. The question is the impact here different or greater in degree than it would be elsewhere of similar zoning? That's what those cases say. And on the zoning by the plebiscite, that's just zoning boards aren't to make decisions based on how many people show up in support of or against a particular request. So, Mr. Ewing, you, in preparation for this hearing, are familiar with the criteria for a special exception, is that correct?
Yes.
You familiarize yourself with the Berlin Code, so I'm now going to direct your attention to section 108-163C of the code, and it says, in considering an application for conditional use or other exception, the Board of Appeals shall give due regard to the nature and condition of all adjacent uses and structures. We've already described the use on this site, which is the microhotel, and we also described how the uses on the adjoining properties or neighboring properties are also commercial in nature. Is that correct?
Correct.
In authorizing any such use or exception, the board may impose such requirements and conditions as to location, construction, equipment, operation, and maintenance. Really, we've not asked for any relief with regard to those items. Would you agree with that?
Yes.
In addition to those expressly stipulated in this chapter for the particular use or exception as the board may deem necessary to prevent or reduce hazardous or congested traffic conditions, we don't believe that should the board look favorably upon this request, it will create any hazardous or congested traffic conditions. Is that correct?
That's correct.
Is that your testimony?
Yes.
Mr. Felici, do you agree with that?
I do.
Odor. This request will cause no odor. Agreed?
Correct.
Mr. Ewing and Mr. Felici?
Correct.
Dust, smoke, or gas. It won't create any of that, meaning this reduction in parking. Correct, Mr. Ewing
Yes.
and Mr. Felici? Noise or other similar nuisances. Again, the only noise would be standard noise of vehicles coming and going to and from this use, correct? Mr. Ewing?
I would say it's not any louder than the traffic on 113.
Or less so.
Yes.
Mr. Felici? Correct. And it may impose such other conditions and requirements as may be necessary in its opinion, meaning the board's opinion, to protect adjacent properties and neighborhoods and prevent conditions which may become obnoxious or offensive. Mr. Ewing, do you believe there's anything about this request that could possibly be deemed obnoxious or offensive? Mr. Felici, same question.
Not at all.
So, under the Berlin Code, it's interesting, there is this section that I referred to, 108-163C, but there's another section of the code which also talks about special exceptions, and that is 108-166. I quite candidly am not sure which one is the controlling section of the code, because they both talk about special exceptions. So I'm going to go through the criteria of the code for the purpose of making the record, so we're just abundantly clear I've addressed everything, okay? So, and I also have this section in the binder under tab 3. So section 108-166 says, in deciding such matters, the board shall give consideration, among other things, to the following. 1, the purpose, application, interpretation, and standards of these regulations as set forth in Article 1 of this chapter. I've already put into the record that your code allows the board the authority to reduce required parking. Do you agree with that, Mr. Ewing?
I do.
Number 2, decisions of the Circuit Court for the county and the Court of Appeals in the state. We're not relying upon any decisions of the Circuit Court or Court of Appeals. The orderly growth and improvement of the neighborhood and community. Well, this property is zoned B3, as I've already indicated, which also allows all uses in B2 and B1, and is consistent with the Berlin Comprehensive Plan. Do you agree, Mr. Ewing?
I do.
The most appropriate use of land and structures in accordance with the comprehensive plan. We've just addressed that. Facilities for sewers, water, schools, traffic, transportation, and other services, and the ability of the town and other public agencies to supply the services. Mr. Zambettis, we have already verified over and over again that should the board look favorably on this request and this project gets built, there are more than adequate facilities and services in the town of Berlin to support this project. Do you agree?
Yes, I've worked on all that.
Mr. Ewing, you agree?
I do.
Okay. 6, the limitations of firefighting and rescue equipment and the means of access for fire and police protection. Again, this project is right off of 113 Franklin Avenue. Access to and from the site could not be any easier. Would you agree, Mr. Ewing?
Yeah, and the fire marshal has looked at a preliminary review and provided comments and did not see anything significant to require a revision to the design.
Great. Number 7, the probable effect of such use upon the peaceful enjoyment of people in their homes. Again, this is a commercial area on the east side of 113. You would not anticipate, should the board look favorably on this request, the peaceful enjoyment of people in their homes being affected, correct?
That is correct.
Number 8, the number of people residing, working, or studying in the immediate vicinity. A lot of people working here, a lot of traffic on 113. Do you believe that that criteria is addressed with this request?
Yes, I do.
Number 9, the type, character, and use of structures in the vicinity, especially where people are apt to gather in large numbers, such as schools, churches, theaters, and the like. The school in this location is on the other side. It's on the west side of 113. And while there is a church on Flower Street, do you agree with me that should the board look favorably on this request and reduce the parking, there will be no detrimental impact to either of the schools or the churches, and there is no theater?
Yes, I agree with that.
Traffic conditions, including facilities for pedestrians such as sidewalks and safety zones and parking facilities available, and the access of cars to highways. Those are issues that have been addressed with the site plan design and will further be addressed with the planning commission. Will you agree with that?
Yep, we've even provided an access to the spaces available on neighboring property and a sidewalk.
11, the preservation of cultural and historic landmarks. I'm unaware of any. Agreed?
Correct. It's in here.
12, the conservation of property values. I would be willing to submit to the board that with the development of this property with the new microtel, that will enhance property values, not be detrimental. Would you agree?
I would.
13, the palpable effect of odors, dust, gas, smoke, fumes, vibration, glare, or noise upon the uses of surrounding properties. I think we've already addressed that. Agreed?
Correct.
And the contribution, if any, of any proposed use, building, or addition would make toward the deterioration of areas in the neighborhoods. There's nothing to believe this would cause any deterioration of the neighborhoods. Would you agree? I agree. So, Mr. Chairman, that's
I'd say
our,
that's pretty thorough.
I tried. Basically, we just want to reduce the required parking by 14, but,
I have a couple questions.
okay.
Mr. Zambidis, when you purchased the property, were you aware of the development restrictions?
What
In
development?
other words, the fact it's a 5-acre lot, but you can't really develop on 5 acres.
The answer is yes. I knew it was 5 acres, 5.1, and we estimated that 2 acres was buildable. So the microtel falls within 1.75 to 2. The problem we had was that the stormwater management is on the property we thought we could use, but we can't. So what ate a lot of the area up is we had to do 3 additional stormwater management ponds, which is excessive. But you can't fight MDE. So Brett at Lane Engineering was able to put this together and make the flow tight within the 1.75 acres needed. So that's why we need that 14 reduction, because we didn't expect the stormwater management that I bought that we can't use. Surface parking is going to go into it. But they're saying, oh no, you can't use it, you need an additional one. So it's absurd, it doesn't make any common sense to me, but we're complying with MDE.
So the engineering of the stormwater management has been approved?
We have submitted to the third-party reviewer and have addressed his comments, and I believe once we get through this process, we are eligible to go back to the planning commission for final approval, yes. We have submitted to them.
Regarding the wetlands, I mean, do you know exactly how many wetlands, non-pilot wetlands are on the property?
Well, we didn't walk all the way to the very back, but I mean, that entire area is wet. And it's been, again, we flagged it all, walked it, and MDE walked it and confirmed it.
I mean, is there any potential to mitigate some of that wetland area to get the spaces you need on your lot?
The issue right now with wetlands is when you exceed 5,000 square feet of wetland impact, you're required to mitigate. Our recent dealings with the state on mitigation are not successful. We have not gone anywhere. Essentially, there's a roadblock to mitigate. A lot of the mitigation banks are not available right now in this area. So essentially, if you have a project that exceeds 5,000 square feet of wetlands, your project's at a standstill for a few years. And so that's the reason why we're really kind of stopping at that wetland boundary and not impacting. We have requested a permit to impact the buffer for grading and stormwater outfall, but just that 25-foot buffer, not into the actual wetland itself. So we have explored that, yes, and it's not viable enough to yield these parking spaces that we need.
And you've looked at other alternative parking alignments? I mean, I noticed you have 2 entrances or exits. I mean,
Yeah, what you see today is, we started this back in 2023, and we've gone through a handful of layouts and designs, and this yields, what you see now, it yields the most parking.
And you were talking too about having 24 additional spaces to use.
That's on the neighboring property.
On the neighboring
And that's in your file, tab 4, I believe, right?
It's right to the east in the parking lot that serves the buildings to our east. There's 20 spaces that align directly
Tab 5, Mr. Barney.
to our property line. And so we would propose to provide a access aisle through one of the spaces and a small little bridge over the existing stormwater for the neighboring property, and then just a connection crosswalk to our hotel. So there's 19 right there, and per the letter that Tom has, there's 5 additional elsewhere on that property that are accessible.
Will that easement be by a recorded document? You will record that you have that easement, and it can't be just removed or taken away? And my concern is if you, well, let me ask one other question. Why 77 units? Why not smaller?
We looked at making a 3-story instead of a 4-story. With a
Right.
cost-benefit analysis, with all the work that we've done with architectural and engineering, it was more expensive to only do a 3-story than to finish doing the 4-story. So we looked at reducing it. However, just like Beacon Hospitality has explained, it rarely, if ever, are 77 full. It's very, very rare. A lot are out of commission. A lot of them they don't even use.
Would you repeat that last?
Yeah.
77? You were saying they rarely.
So, allow me. Basically, when you have 77 rooms, and we have 3 microtels, 4 hotels total in Rehoboth, Milford, Georgetown, you never typically have all your rooms in service. There's always, no matter how hard you try, you typically have a few rooms that are out of service. You only operate at maximum capacity, maybe sold out maybe 10 to 12 times a year. But typically, if you look at an average hotel, your annual occupancy is 50% or less. So most of the time, you're going to have more spaces on the site itself than you will at any point in time. That overflow parking will be rarely used.
And one other thing, the parking that I have access to from Neve, which is the gentleman who I bought it from, and he has all the properties behind it and the condominiums here. The 2 parking areas are contiguous. They're right next to one another. So it's as though there's an extension to ours, and we're just going to, have a little trail right over to it, and it's seamless. It's not as though they have to park down the street or around the corner. And these parking spaces are always empty. I'm not saying, I mean always empty. At the 911 call center, everyone parks on the the east side of the building. No one ever parks over here. That's why Neve said, sure, you can have it. No problem.
And for what it's worth too, Mark mentioned the other jurisdictions and the regulations. I think what we failed to mention also was the shared parking aspect. I think that's what these other jurisdictions allow are compatible uses, quote unquote. And you have a hotel that has its demand on, as Ernie and Tom would know, evenings and weekends, as opposed to an office building next door that is 9 to 5, 8 to 5 during the weekday. So that's how you would comply in these other jurisdictions, by having a shared component and it being within a certain distance of that property. There's language in there that allows a certain percentage to be reduced based on that.
And that's what we have at our Rehoboth Beach property. We have 20-some overflow spaces that Tanger Atlas owns that allows us to use. We have a cross parking easement with them.
Okay.
And we never use that lot.
Yeah, because my initial concern was you know, a guest coming in at 7, 8 o'clock at night to rent a room and not having a place to park the car would be very frustrating. And I was looking at the surrounding property, the property to the east. I didn't realize at the time you all had an agreement or an easement to use that. I mean, 24 spaces would make up a major difference. The biggest conflict we have with the code is you just don't have it on site.
That's correct.
And you're testifying that the spaces you will be using, you see them very seldom even occupied.
Go there anytime, you'll see them, they're empty.
I'd like to ask, Frank, I don't know if you would have any knowledge of this or not, but when the other property was developed, what were their parking requirements? Or is this the number they needed? You probably aren't aware.
I'm not sure.
And I didn't do that project, so don't.
Yeah. I was just trying to figure that out. Anybody else have any questions they'd like to ask?
Other than the crucial issue of the cost, okay, are there any other micro motels that have less than 77 units? Are there any?
Yes. The Microtel in West Ocean City has less, and it's a 4-story, 77-room hotel.
And it's a 4-story too?
Yes.
It has less what?
Less parking, that was the answer.
Oh, no. I mean, do you have anything that has less than 77 units?
Oh, a prototype? No, sir.
No.
No.
Ours are 77, 78 rooms.
All microtels are.
The basic prototype is 80 rooms, and then depending if you're putting a fitness room or how large you make your conference, or your meeting room, that's where the variation lies from 77 to 80. So Milford has
I
a
wondered why you picked 77.
It's also that if you remove a story, it no longer, it doesn't pencil. It doesn't make sense to build it. So Wyndham Microtel came up with that the 4-story prototype it will achieve the return that makes sense for a builder.
Mm-hmm.
You know?
Like building a house?
Yes.
A small house versus a big house that all costs the same?
So you just hit the nail on the head.
Yeah, okay. So I have a question. So have you thought about having an indoor pool versus the outdoor pool? Because then that would give you some additional parking spaces.
The proprietary design of the Moda style of this is to have an outside pool. The engineering is not conducive for an inside pool.
And I think that it would be just covering the existing footprint of the pool now, because there's no space for the pool inside the building.
Right, you'd have to give up a few rooms.
You would have to go up basically the first floor.
Oh, okay.
By the time you put, I don't know Maryland's code, but you have to have an extra bathroom for the pool, and then you
Right.
got to have the pool room, and then the circulation, the 4 feet around the pool.
Okay.
You would end up taking up all the rooms on the first floor, which is
Would
half
solve-
of what's on the top. the other floors.
Would solve the parking problem.
But would be cost effective to build.
Okay.
Is the cost, to rent the unit, the microtel, is that similar to what they're paying in Ocean City? Is it less than that, or what are we talking about as far as that figure is concerned?
Well, right now it's going to be a little bit of an unknown because you really don't have a hotel in Berlin.
Right. But,
So, I mean, our hope that off-season we'd be floating around the $100 per room night.
Oh.
And then, during the season when things are hopping and we're overflow for Ocean City or, people that want to come into Berlin and sporting events and that will be probably closer to the $200-300 a night rate. But we don't know until we hit the market. But we would assume that's similar to our Milford and Georgetown locations.
I was wondering what your rationale was in reference to, you stated that there would be probably an increase in property value with this, addition. What is your rationale for that?
Right now, you have an empty, undeveloped piece of land. It's providing no enhanced value, not only for this site, but for the surrounding areas. You put a brand-new structure, a hotel, this micro-hotel, because it's new and because it's consistent with the code, it will, generate commercial activity, which benefits the neighboring commercial properties. Because generally, commercial properties support each other and assist each other. So if you compare no use, no building on an empty lot, which is what we have today, versus a new hotel on that property with a vibrant commercial use, it's my opinion that that will enhance the value of the surrounding commercial properties. Because there's nothing there now.
Right.
Yeah.
And just the number of users, folks using the services nearby in Berlin, restaurants, gas stations, et cetera, it just increases that.
And if you have, well, consistent with what Mr. Ewing just said, if you have people traveling along the East Coast using 113, they choose to stay at the microtel, those people very likely are going to go to your local bars and restaurants that night in the town of Berlin. That helps everybody. I mean, because people, instead of just passing through and continuing north or continuing south, are going to stay here overnight or over the weekend. And so the local businesses will do nothing but benefit from that. So I think that also enhances the value, especially of the commercial properties in and around the town of Berlin.
I was also wondering, have you had any dialogue with residents in town or business owners in reference to where perhaps they're coming from as far as their attitudes?
With regard to this request?
Pardon?
You mean with regard to this request, the reduction
Yes.
in parking?
Have you had any dialogue with people in town?
I haven't, no.
The restaurants and bars are looking forward to the hotel coming for the same reason that Ernie said, people are going to stay there. We don't have food service. They're going to go out to restaurants and bars. So they want the hotel to show up. They need a hotel. Atlantic, a great hotel, we just had dinner tonight, only has 14 rooms. This is going to be 77, so it's going to bring more people in the area for economic development. But the other thing, and I mentioned this to the mayor, and he agreed, is that every time of the 77 rooms we flush a toilet, or run a sink, or take a shower, the city's making money on the water and the sewer. Electricity use. They're going to make money, the town of Berlin's going to make money on the electricity. The property tax that we'll be paying is so there's so many benefits, but the side benefit would be the overflow for food and for food and beverage and all they're all excited about us being there.
Well, the one thing I'll add to that, kind of in closing, is the one nice thing about a hotel or motel on this property, it spreads economic development throughout the town of Berlin and puts no kids in schools. So there's no impact on the schools whatsoever from developing this property. It's a multi-million dollar improvement to the town of Berlin, and the schools aren't impacted. So it's a net benefit no matter how you look at it.
I have a question about the parking spaces. Are they all the same size, or do you have some compact spaces and some truck spaces?
They're all the standard size.
Okay, and have you considered having a section that might be compact?
Well, the code doesn't speak to a compact section that I'm aware of. So we designed this consistent with the minimum dimensions and standards in the Berlin code, and which is pretty typical for most jurisdictions that I work in, 9 by 18 or 9 by 20 space.
Okay.
So we did not look at smaller spaces. We do have a couple of EV spaces for charging of electric vehicles.
So you're gonna have chargers?
We will have chargers at a few locations near the handicap spaces to the west of those, but no, all the spaces are of the same size.
Okay.
There's one other section of the Berlin Code that I was looking at, talking about lot area. I mean, you mentioned you knew when you purchased the property, it had about 2 acres of usable land.
Yes.
There's a section of the code that requires for each unit 2,000 square feet of area. I think if you, I haven't divided that out, but if you divide 2,000 square feet into 2 acres, you're not going to come out with 77 units. How do you explain something like that?
Well, I'm not sure the units, is that in the hotel regulations, or is that
Yeah,
in?
it's Berlin Code, it's 108-440. With
Yeah.
lot area with yard requirements for hotels. One of them is 2,000 square feet lot area per unit. Now, the 5 acre lot would meet it.
Sure.
But we already know that.
Mr. Bonnie, give me that code section, please.
108-440.
440.
Section 108-440. It's 2,000 square feet per unit. And I'm just trying to figure out how that fits into our plan.
Well, I mean, I guess, is there a definition of lot area? Because again, like you said, I mean, we do
To be
comply
honest
with
with
the
you, I
5
couldn't
acres.
find that.
What's that?
To be honest with you, I couldn't find that.
Yeah.
But the
Well,
only
wouldn't
way
that
to
be
make
a-
that work is to use an untitled wetland.
Yeah.
Well, exactly, but I guess that's, I think we, again, it's been, we started this in 2023, so forgive me for not remembering that exactly, but looking at that and using the 5 acres is, you know,
It's
because
the only way to justify it.
well, correct, it's 3.5 acres using, 77 times 2,000.
And you threw me for a loop there, Mr. Bunning, because we've been before the planning commission, I don't know how many times, and you're the
Yeah.
first person to bring that up.
Yeah. And I think it's because of the 5 acres. that
Well, I was
we-
actually looking for a way that the code needs to define that better,
Oh, yeah.
because under lot area, they should tell you what you can use.
Well, that's right, that's right. And most codes, in fact, do.
Yeah. Yeah, because I think in Worcester County, they identify
They
what
do.
percent
They
of
do.
that you can use. Anyway, it's kind of the mood right now.
Right.
Any other questions by the board?
So would you be able to get an easement into perpetuity for that parking? That you would have it in as a legal document?
The parking on the neighboring property
Right.
is shared parking. And so, and I don't represent need properties,
Right.
but just speaking generally, I'm not sure how he could give an easement that dedicates that parking specifically for use of this project, as long as it's continued shared use on that property. In other words, both properties have access to it. So I'm not really sure how we would draft that document, because it's not exclusively dedicated.
I think what really asking is to be guaranteed that it can't be taken away.
Right.
Right.
What happens if Mr. Patel, he's Neve,
Right.
he decides that he's going to sell all of that property?
I understand.
And now you're sitting here with the loss of
The 24.
14
right.
or 24 potential parking spots. how does that affect you in the future? So that's where I'm getting at.
Yeah, and I-
Do we have something that's going to be guaranteed forever?
I think we'll have to, when I said we, I mean, Mr. Zambetta, speak with Mr. Need to see how we can address that concern. Because the intent here is obviously that it be there in perpetuity as long as the microtel is up. So yes, I'm very appreciative of the issue.
I spoke with Mr. Patel last week. He said, look, if you need us to do anything to help facilitate this, he said, we'll do what you need to help. He's afraid, candidly, to give exclusivity to it because it might take away from his parking for his condo back in there. So he says, you know, his attorney drew it up. He says, we'll go ahead and do whatever you want. He wants the hotel to come in. He knows that the hotel's going to raise the value of his. So I had that conversation with him.
So we can have that discussion with him.
I'm sure both parties would want probably some shared use and access, maintenance, you know,
Right.
some sort of agreement that everybody, you know, is equally kind of maintaining this area as well.
Any other questions?
Are you going to act on that issue?
Oh, sure, yes. We'll follow up with Mr. Need, or well, Mr. Patel, I keep saying Mr.
Is there anyone in the audience who might wish to speak for or against the project? Come forward, please. If you'll raise your right hand, you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
State your name, please. and address.
Christopher Denny, 9923 Old Ocean City Boulevard, Berlin. I just, what is the net parking spaces that are left? That's the question.
I'm sorry, sir, I can't hear you.
69, if the board grants the relief requested, we would be providing 69 versus 83 on site.
So, okay.
So
On site,
On site. What you're seeing up on that screen
In gray.
is 69 parking spaces instead of 83.
okay, and then you have the 20, by the way, I was on the planning commission for 25 years. I was a former chairman for 12 years. I just did not renew back in November. I'm officially retired from it, so I'm speaking as a citizen, which all the information that I have is all public knowledge, so I'm not, okay? I'm just saying, I mean, the whole project, when the applicant was in talking about changing the building and all that, he knew how big the building had to be and et cetera, et cetera. I assume you'd not have to know how much land you would need to be able to build this project. I think with the 24 off-site spaces and then the addition of taking this away is quite a bit. I mean, that's 77 rooms and 69 parking spaces. I mean, you just do the math right there. I mean, I wouldn't build a hotel. I'm not a hotel guy. But I would have enough, I wouldn't build a hotel unless I was thinking I'm going to fill it up every night.
Well, I mean, are you, clarify for me, are you testifying that you approve or oppose to the request?
I'm opposed to the parking there, yes, opposed.
But if they meet with the other 24 spaces, is that satisfactory?
No, I just think they're putting way too much there for, they knew going in how much space they needed for land. And just, it doesn't make any, it wouldn't make any sense. They're just trying to stick a lot there for something to achieve. It's not beneficial to the town.
All right, thank you, sir.
Mm-hmm.
Is there? That's Chris Denny. Anyone else who wishes to speak for or against? Any other questions from the board? Any other?
No, the only thing I would say in closing, somewhat in response to Mr. Denny's comments, Mr. Zambettis wouldn't invest these many millions of dollars into this project with 69 parking spaces unless he thought it was going to be successful. So while I respect Mr. Denny and I hear his comments, it's a business judgment decision, and in light of the fact that, you heard testimony this evening that Mr. Felici's experience with microtels have apparently worked extremely well, providing the same number of parking spaces for the same number of rooms. I trust Mr. Felici and Mr. Zambettis to know what they're doing, and they wouldn't do this, Mr. Zambettis' money, unless he thought it was going to work. So we appreciate the board's time and consideration. Again, this is a special exception, and we would ask you to grant the parking reduction of 14 spaces.
Emily Morris, I'm counsel for the board. I just want to remind the board that under Berlin Code Section 102, 101, you have the authority to put conditions on any granting of relief. And it could be a non-exclusive easement. It doesn't have to be an exclusive easement.
Yeah, I guess my concern is the granting of a variance. I'm trying to balance it. I don't want to set a precedent.
The code actually calls it a variance. I think what is being presented to you is a special exception because that's the way that they're interpreting the code. But either way, you have the authority under, whether you call it a special exception or a variance, you still have the authority to issue a relief, we'll just call it relief, whether it is a special exception or a variance, subject to whatever conditions you feel appropriate.
I mean, to me, the relief is the 24 spaces without the 24 spaces.
Whether you call it a special exception or a variance, yes.
Okay. And then this is time for us to decide. Any discussion? Now, the way sure. I mean, it's public. We can still talk. It's not going to be a private talk.
What I'm wondering is, if we held off
Well, I think they testified that there will be. We're going to look into the.
yeah, but it's not.
Well, we can make it conditional. What I'm going to do, Mr. Cropper, is just, there's 4 things here that apparently is required of us under the code to consider for the granting or of this. Granting or approval.
Okay, but let me ask this, Mr. Chairman.
Sure.
The 4 things we're talking about, are they under variance or special exception?
If I could clarify that would be, it's actually, if you cited to the code requirements that you've actually cited to under, that you're requesting relief, I think it's under the section 108, 788, section 4. Oh, actually, that's not the right code section. Where are you having the relief in your tab number 3? Says number 4. I don't know what code.
Oh, yeah, you're,
it says
more,
yeah.
You're talking about 108, 788, 4.
Yes, and it says subject to provisions of 108.
Yes.
So it's 108-160 through 108-165.
Right.
And those from 165, 108, 165 has very specific requirements that it be decided, that the board had, that they decided that there was extraordinary circumstances that do not apply to other B3. But this is where I think there's some there's some discrepancies in the code that Mr. Cropper has determined to pursue the easier route, which is a special exception. That is the position that's been presented.
But let me say this. I said at the very beginning of this hearing that because of section, let me finish, 108-163 that says all such applications shall be deemed to be for special exceptions. And I asked in the very beginning, if anybody disagreed that this was proceeding as a special exception, let me know. And nobody said anything. If we're now going to be proceeding under 108-165, which is variances, the criteria are much different, and I need to address those criteria, which I have not done in my testimony. So I proceeded based upon my understanding of the code and how I introduced this matter. If the board is now going to rely upon 108-165, A, B, and C, which are the variance criteria, then I need to address them specifically because they're different than for special exceptions. And your code, again, I'm going by the Town of Berlin code, where it says the board shall have the power to authorize on appeal in specific cases a variance from the terms of an ordinance, and the ordinance we're seeking a variance from is the parking requirement. All such applications shall be deemed to be for special exceptions. So I address special exception criteria. I did not address variances, but if the board believes that this requires a variance, then I would ask your permission now to go through the variance criteria with my client so I can make the appropriate record.
But there is some discrepancy in the code that he's utilizing
Yeah,
to
I'm
make a
trying to
case.
understand.
And I do think it would be my advice to the board that you hear his case for a variance because he applied for a variance and that in the application it calls it a variance. And whether the standard of review is a special exception, which is a lower burden of proof, is a separate thing than actually meeting the other code requirements because there's a specific reference to section 108 through 108-165, which is the variance standard.
And
When it's speaking of actual parking, it may not be a burden that it could be that they'll meet the burden. I'm just telling you that the code requires you to also consider 108-165.
And your application form that was provided to me by the Town of Berlin has application for variance, conditional use, or appeal. There is no square for special exception. So I had to fill out the form as provided, and I will recognize for the record that the Berlin Code says, while this is a variance to the terms of the provisions of the code because we're seeking a reduction in the code required parking, the code then says treated as a special exception. Different criteria. A special exception is a presumptively permitted use. A variance is not. A special exception, you don't have to prove unwarranted hardship. A variance you do. So it's apples and oranges. So if the board believes that this is a variance irrespective of the code saying otherwise, then we need to address the variance provisions. And I didn't write the code. I'm going by your code in presenting this case.
Well, maybe to be safe, if you address the
Sure.
variance provisions.
Absolutely.
Yes.
Yeah.
You're dealing with three people up here who aren't attorneys.
I realize that. Okay, 108-165A, where by reason of the exceptional narrowness, shallowness, or unusual shape of a specific piece of property on the effective date of the ordinance from which this chapter is derived, or by reason of exceptional topographic conditions or other extraordinary situation or condition of such piece of property, or of the use of development of property immediately adjoining the piece of property in question, the literal enforcement of the requirements of this article would involve practical difficulty or would cause unnecessary hardship, unnecessary to carry out the spirit and purpose of this chapter. The board shall have the power upon appeal in specific cases filed as herein before provided to authorize such variance from the terms of this chapter as will relieve such hardship, so that the spirit and purpose of this chapter shall be observed and substantial justice done. So my first question of Mr. Ewing, do you agree with me that this property has an exceptional and unique shape and condition that warrants a variance from the terms of the title regarding parking, yes or no?
It does, yes.
And it has exceptional topographic conditions or other extraordinary situation or condition that we didn't create, meaning the non-tidal wetlands on the site and the stormwater management limitations, restrictions, and the enhanced stormwater management components that we had to design on the site that was unknown in the very beginning.
I'd say the shape of the lot, those items you mentioned, the state highway, access easement that allows no encroachment, all those are unique to this property, in my opinion.
The code further states, no such variance in the provisions or requirement of this chapter shall be authorized by the board unless the board finds by a preponderance of the evidence that all the following facts and conditions exist. Number one, that there are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes of uses in the same zoning district. And the exceptional or extraordinary circumstances or conditions are ones that you've already described regarding the stormwater management, the non-tidal wetlands, among other things, neither of which did we create, correct?
Over 3 acres of wetlands and a B3 zone in the town of Berlin is an exceptional case.
Number two, that such variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the same zoning district and in the same vicinity. This property is zoned B3, which allows all uses in B3, B2, and B1, correct?
Yes.
It is, the use is consistent with the Town of Berlin Comprehensive Land Use Plan, correct?
Yes.
And the site as designed is consistent with the design of any site where you're going to put a hotel or motel on a B3 zone piece of property within the town limits, correct?
That is correct.
And the same limitations or conditions would create a similar hardship for anybody having to comply with these circumstances,
Yes.
correct? Number three, that the authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of this chapter or the public interest. First, the nearest property is the adjacent property where the owner of the property has offered shared use of 24 parking spaces, correct?
Yes.
So there is no substantial detriment. If the board should look favorably upon this, there would be no substantial detriment to the adjacent property because the adjacent property supports the project and has offered shared use of the 24 parking spaces. Agreed?
And in fact, based on our testimony earlier, it would likely enhance the businesses in the area.
And will not materially impair the purpose of this chapter or public interest. Would you agree with me? It's hard to even fathom an argument where this use, and this is not a special exception use, this is a principal permitted use in the B3 zone. So there's no way if this project gets developed with the microtel, it will impair the purpose of the chapter. In fact, it's consistent with the chapter. Would you agree?
Yes.
And as far as the public interest, it's in the interest of the public that the town of Berlin facilitates development within the town limits consistent with the zoning code and consistent with the comprehensive land use plan, both of which support the microtel on this property.
And the fact that there's sufficient parking with the 24 spaces next door. So yes, I agree.
The final criteria under variance says under subsection C, no grant of a variance shall be authorized unless the board specifically finds that the condition or situation of the specific piece of property or the intended use of said property for which variance is sought, one or the other or in combination, is not of so general or recurrent a nature as to make reasonably practical the formation of a general regulation for such condition or situation to be adopted by the mayor and council as an amendment to this chapter, which means that it's only because of the unique circumstance and conditions on this site, unique to this site, that there is no legislation of what we call general applicability that can be adopted by the mayor and council as a text amendment to the code to address this exact situation. It is specific, it's unique, and it's exceptional, and it wasn't caused by the applicant. Would you agree
I
with that?
believe this addresses that warrant, yes.
Those are the criteria.
Thank you, sir.
Yes, sir.
Are there any other questions from the board regarding that last testimony? Anybody in the audience have any questions regarding that last testimony before we proceed? All right. Do we have a motion, or how do we want to proceed from here? What I was going to do, to make it easy, so that we can vote, is vote on these 4 conditions.
Okay.
Which is, I'll read them again.
Which is the one that? Yes, it's number 3.
Reflection will not be, well, yeah, but when we finally make our motion, I think we're going to make our motion contingent on
That's
a certain, that's what you want to make sure. Well, I mean, you just want to go ahead, well, let's go down each one of these and just see what your opinion is, vote on them. The exceptional or extraordinary circumstances or conditions apply to the property. Wait a minute. He's presented evidence, by a preponderance of the evidence, that we support, that we agree with what they propose, exceptional and extraordinary circumstances. Do you agree with the testimony they gave concerning that?
Yes.
I so agree.
We all agree that there are exceptional conditions, and mainly, in that, I think in that particular case, it's the 2.5 to 2 acres of non-tidal wetland. I don't think other properties would have that degree of wetland. That the variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the same zoning district and in the same vicinity. The testimony they gave concerning that, do you agree that was substantial?
Because, we need to vote, I mean.
Yes, we voted yes on number 1, that was a positive. On number 2, when I just quoted Mr. Cropper, would you explain that to us again one more time?
And I want to make sure you and I are talking about the same language here. That such variance is necessary for the, are we on the same one?
Yeah, for the
Okay.
preservation.
For the preservation and enjoyment of substantial property rights possessed by other properties in the same zoning district and in the same vicinity. So there, you have only so many properties in Berlin within the town limits zone B3, that's your most intense commercial zoning in the town of Berlin. And you have 5 acres, of which less than 2 are even viable and usable, so that to preserve the enjoyment of the substantial property rights owning a B3 zone piece of property, which we're trying to accommodate and facilitate, we believe that any B3 zone property, because a motel or hotel is a permitted, principal permitted use on B3 zone property, in order to do that on this property,
That the variance is
the
necessary.
variance is necessary, because otherwise you can't utilize the rights afforded under your B3 zoning district without the variance. Yes.
Do you members agree with Mr.
Yes.
Cropper's statement?
I agree.
We all agree on that. the reduction in required parking spaces will not be to the substantial detriment of the adjacent property and will not materially impair the purpose of this chapter or the public interest. Do you agree? That's true. True or false? I mean, it's my opinion, with the recorded
Yes.
easement and agreement, which I think is important, that addresses that issue and will not be to the detriment of the adjacent property because it's with their approval.
It's with their approval, that's right.
We all agree to that statement?
Yes.
Okay.
But I want something in writing.
Understood.
Okay.
Yes.
Right, and you can condition the approval on that.
Yeah, I think, okay. Number 4, that the condition or situation of that property, specific piece of property or intended use of property for which the variance is sought, one or other or in combination, is not of so general or recurrent in nature as to make reasonably practical the formation of a general regulation for such condition or situation. Any discussion? I would like, for some reason, I read that and I get all twisted.
The summary,
Explain that one more
basically,
time.
the intent is, does it create a precedent that the board will have to abide by in the future? If it were to
Well,
grant this.
In that case, I mean, it would be my opinion here that it doesn't create a precedent in the sense that this property has unique characteristics that we're not going to find on other properties. So I don't see that as, because I don't want to set a precedent for the first hotel.
Exactly.
I'm telling you, you will not set a precedent with this, because no other property in Berlin Zone B3 has these issues.
I mean, that was
And
my
we'll have,
answer.
and we'll have 24 spaces available directly next door.
Yeah.
Yeah, and without those 24 spaces, I think it might have been a different matter tonight.
Right.
Would anyone like to make a motion?
I make a motion that according to the information that you just went over, with 1, 2, 3, and 4, I so approve.
Are there conditions? Are you conditioning it, or is it?
You have the condition.
Condition to,
Oh, in condition 2, that we also get a written documentation that states a clarification of the issue we discussed regarding the 24 spaces.
is there a second?
I second that.
All in favor, say aye.
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 Thank you very much. Appreciate your time.
Thank you.
Thank you for your detailed presentation.
Just make sure, I want to make sure the record is clear. When you say clarification, what is specifically you requesting that they do? Are you requesting an easement to
That
support it?
there be a recorded document on the shared use of the 24 spaces on the adjoining property.
And if Mr. Patel sells it, that you still have access to that.
With that spaces.
I understand.
I mean, that's clear?
I just want to make sure the record is clear about what specifically you're requesting, because this is your order, so I want to make sure that it's
You
clear.
understand that, right?
I understand.
Yep.
Thank you, gentlemen.
Thank you. Appreciate your time. Do you want the binders or no?
Can I get one?
Sure, keep as many as you want. I'm just asking if you want them. Did you like the binder, Mr. Herman?
Well, I was going to actually leave it with Pam.
That's fine.
Say one of these photos I know.
We've got.
It is nice binder. I was one of the very detailed.
I'm Emily Morris, nice to meet you. Congratulations on your hotel.
Oh, thank you. Right, you.
Yeah.
Oh, hi, nice to meet you.
Oh, yeah.
Oh, hi, no, that was, nice to meet you. Good luck with your hotel.
Thank you.
Are there any, before we go, are there any other comments from staff? You brought them to the board. Any other comments from the board? If not, meeting.
Nice to see you.
Adjourned.
I second that motion.